Hello and welcome to this informational video from INDIALAW LLP. My name is Divy Lotia and today we are discussing a significant Supreme Court judgment in the case of Brij Bihari Gupta versus Manmeet and others, which addresses liability in motor accident claims, particularly regarding insurance coverage and vehicle ownership transfers. In this video, we will cover the case background, the court's legal reasoning and its implications. So let's dive in. The case originated from a motor vehicle accident leading to compensation award by the Motor Accidents Claim Tribunal (MACT). The MACT held the registered owner, the driver, that is the appellant Brij Bihari Gupta, and the insurance company jointly and severally liable for the victim's claims. The insurance company challenged this in an appeal to the High Court of Chhattisgarh, arguing it should be absolved of liability because the injured were gracious passengers and because the vehicle's ownerships and possession had been transferred to the appellant, that is the driver, voiding the policy. The High Court sided with the insurer, exonerating it. This prompted the appellant to appeal to the Supreme Court, raising core issues about whether the passengers were gracious passengers and if the ownership transferred affected the insurer's responsibility to indemnify the registered owner. The Supreme Court's reasoning cantered on interpreting the Motor Vehicles Act 1988 to protect accident victims. It rejected the insurance company's key arguments. First, on insurer liability for passengers in a goods vehicle, the insurer claimed the injured and deceased were gracious passengers, which would typically exempt it from liability. However, the court found this unsubstantiated, relying on claimants' depositions showing they were petty hawkers carrying goods like fish and vegetables. Thus, they were not gracious passengers. This is supported by Section 147, subsection 1, B, subsection 1 of the Motor Vehicles Act 1988, which covers the owner of the goods or his authorized representative carried in the motor vehicle as a third party under insurance policy. Therefore, the insurer remained liable to indemnify the registered owner for the death or injury. Next, on transfer of ownership, the court examined the agreement between the registered owner and the appellant. It was conditional on a final payment of Rs 10,000 which hadn't been made by the accident date. Under Section 50 of the Motor Vehicle Act 1988, the transfer of registration hadn't occurred, so the registered owner remained the legal owner. Regarding liability, after an incomplete vehicle transfer, the insurer argued that the agreement shifted possession to the appellant, ending its liability. But the Supreme Court found the transfer incomplete as the agreement required the balance payment for the registration transfer, which was pending. Section 50 mandates reporting the transfer to the registering authority within 14 days, which wasn't done. Thus, ownership stayed with the registered owner and the insurer's indemnity obligation continued. The court cited its precedents in Naveen Kumar versus Vijay Kumar and others, emphasizing that the definition of owner under the Act should be interpreted to protect claimants. In its judicial reasoning, the Supreme Court upheld the principle of the Motor Vehicles Act to ensure victims' protection, rejecting the insurer's attempt to avoid liability based on an unsubstantiated claims and incomplete transfer. The outcome reinstated the insurer's liability, modifying the High Court's order accordingly. In conclusion, this Supreme Court judgment reinforces that the insurer liability in motor accidents depends on proper interpretation of ownership and passenger statutes under the Motor Vehicle Act 1988. It prioritizes protecting claimants over technical escapes for insurers, especially in cases of incomplete vehicle transfers. Thank you for patiently listening to this information. This is Divy Lotia signing off. For more such information, contact us at contact@indialaw.in. Thank you.